Hello and welcome everybody. Welcome back to my channel When Humanities is Life. In this video, we will be discussing about the law of torts, which is part C of your Unit 2 Topics of Law. Now we need to know what's the tort. It originates from a Latin word tortum, which means twisted or crooked. It's a wrongful act, as we can understand. Now these two definitions are very important for your tests. Tort is a civil wrong or a wrongful act, either intentional or accidental, and it results in the injury or harm to another person, who in turn has recourse to civil remedies. The language is pretty much clear here. The tort suit is pursued in a civil court where the victim or victim's representatives prosecute the wrongdoer for compensation in the form of money payment, a very important thing. So we need to remember that in any tort case, the victim or the victim's representatives gets money from the wrongdoer. That's what makes the tort an ideal target for the ones who are trying to pursue it, who are trying to punish criminals or wrongdoers or opponents for any kind of injury. Occasionally, courts may also grant punitive damages. Punitive damages means these are costs or damages in excess of the compensation. They have to give more money right now. Torts can be either intentional or accidental. Includes battery and assault, negligence, nuisance, defamation, property damage, trespass, etc. And sometimes it overlaps with other areas of law. And there are three kinds of torts: intentional tort, negligence tort, and strict liability. Intentional tort includes battery and assault, false imprisonment, trespass to land, trespass to chattel, conversion, unlawful harassment, and invasion of privacy. These 7 categories. Negligence is 3 parts, and strict liability is a very important area in your syllabus. Now, since we have to refer to tort law, but what's the source? The source, there is no source. In fact, there is no specific laws governing tort incidents. Judges follow judicial precedents. So centuries of judicial precedents are the main sources from which we know about tort law. There is no statute, no law has ever been passed in any legislature till date that comprehensively deals with tort as a separate area. Judges who render decisions in connection to tort cases, these decisions are the ones which act as important sources for us to refer to. But there are some areas where countries have enacted laws, like the Motor Vehicles Act of 1988 or the Consumer Protection Act of 1986. These are certain laws that have been enacted in the area of tort law. Then we come to the first type of tort, intentional tort. It requires the claimant to show 3 things. First of all, the defendant caused the injury on purpose. Second thing, the claimant suffered a particular consequence because of the injury. And third thing, the defendant's action caused the consequence. Defendant caused it on purpose, the claimant suffered an injury because of that, and the defendant's action caused the particular injury or consequence. The 3 things. And there are many aspects of criminal law in torts. For instance, if somebody is beaten, definitely there is something about criminal law involved here. But if we treat it as a tort subject, it increases the possibility of higher compensation. So we get money from the wrongdoer, the opponent, the defendant. That's why we often use tort law while prosecuting the wrongdoers, as I already said. Next, we come to battery and assault, the first part of intentional tort. Battery and assault. What is battery? You need to mention 3 things here. First of all, battery occurs when the defendant causes the touching of the claimant with the intention of causing harm. So touching of the claimant with the intention to cause harm. Touching is an important keyword here. Both intent and causation is required. The wrongdoer should have the intention to cause the harm, and the person should actually do it. And that action of the defendant or the wrongdoer should in fact cause a real damage or harm to the victim. Then only the intentional tort of battery will occur. There is an example given here. Defendant intended to hit the claimant on the head. That was a battery. Now, in all these cases, these examples are taken from NCERT, and you will write what is there in NCERT. I always say this to everybody. So, here whatever is written in the textbook, you are going to write it. Touching can be by any way. Next we come to assault. Assault occurs when the defendant intends to cause in the claimant a reasonable apprehension. The intention of the defendant is to create an inevitable fear in the minds of the person. Now, here the language in your textbook is extremely ambiguous. It's confusing. So don't get influenced by that. You simply go on following this simple explanation given in this video. So this reasonable apprehension is a must element to constitute the intentional tort of assault. Perception of the claimant is important here. For instance, if the defendant throws an iron ball towards the claimant but he misses him as the claimant moved his head away, that's assault, because the claimant might have been afraid that he or she would be injured by that. The perception, as I said, was important. The fear is an essential thing here. Now, assault can take place without battery, and battery can take place without assault. There are two examples here. You need to remember them. There is nothing much to explain here. You just remember the four categories: battery, assault, assault taking place without battery, battery taking place without assault. The next subsection under intentional tort is false imprisonment. The tort of false imprisonment is satisfied when there is an intent to unlawfully confine and restrain the claimant in a bounded area, and the claimant is knowingly confined in the bounded area unlawfully. That's the definition of the intentional tort of false imprisonment. So clearly the claimant had been locked up in an area and the person knew that he was confined. Definitely the person had been afraid. For instance, defendant unlawfully traps a claimant in the classroom. There can be a question in your exam asking, if a teacher unlawfully confines a student in a classroom for being mischievous, is it illegal or not? Obviously it's illegal. And which tort can be used to sue the teacher? You will write false imprisonment and explain the point that I mentioned here and everything that's there in the textbook. Now, there is nothing that is not there in the notes which is there in the textbook. Textbook is important. I will again repeat. Now, there are two things that we need to keep in mind. The claimant should not be trapped willingly or consensually. I guess you cannot see this, but yes, it's willingly or consensually. The person should not be consensually trapped. Then it won't constitute the intentional tort of false imprisonment. Next, we have trespass to land. In trespass to land, trespass means illegally entering an area where we have no claim, we have no right. We physically invade real property, and this actually happens without the claimant's permission. Now, the owner of the property has no idea, no clue that we are actually entering and invading their property. This is without his or her approval or consent. Then it's trespass to land. Invasion can be through objects, people, invasion of some area above the land, invasion of some area below the land. Suppose I am flying a drone above somebody's house, capturing pictures and doing something, or maybe throwing something from the drone. These things are illegal, and what we are doing is trespass to land. Or even if we are digging something under the house, maybe a tunnel or something, that's also an illegal thing. For instance, the defendant may litter the claimant's land, may create a drainage outlet below the claimant's land. As I said, this is invading some area below the land. These things are all illegal, falling under trespass to land. Then we have trespass to chattels. First of all, what do you mean by chattels? Chattels means movable personal property. For instance, a car. When the defendant has the intention to use or intermeddle with the movable personal property or chattel which was in the possession of the claimant, and when this actually is done, causing significant dispossession, deprivation of use, or damage. You have to mention these three words and this definition whenever you are giving the explanation of trespass to chattels. Alright, I've even marked this in subsections by enclosing it in brackets so that it's easier for you. Alright, so it's about the intention to use or steal the movable personal property of the claimant which was in the possession of the claimant, and when this is actually done, causing dispossession, damage, etc. This causes harm in the legally secure interests of the claimant. For instance, the defendant paints the car of the claimant which was parked outside the park or maybe at the road. This is trespass to shuttles. Lastly, we have conversion. We have one more thing. Unlawful harassment. So conversion conversion occurs when the defendant intentionally uses or intermeddles the chattel or the movable personal property in such a serious way that it becomes fair to ask for total prior value of the chattel. So conversion is more serious than trespass to chattel. What happens here? The thing is totally damaged. Maybe it's given to somebody, it's absolutely out of reach, something like this. The remedy in conversion is forced sale. If somebody has stolen my property, the person has to pay the entire money. If somebody has taken my car, damaged it, now the person has to return the car with actual interest. This is applicable when the chattel is transferred to someone else, taken, changed, misused, or damaged. In these 5 cases, conversion is applicable. Next, we have unlawful harassment. What happens here? The defendant may be held liable for any act of deliberate physical harm to the victim, even if there is no battery or assault involved. There is an intentional physical harm that the wrongdoer has done to the victim. Even if he has not been physically violent, there has been no battery or no assault, but still he has done a physical harm. Like for instance, this example is very interesting in the textbook. If the defendant lies to the claimant that the latter's son has died in a car accident, which causes nervous shock in the claimant, resulting in illness, that's a tort of unlawful harassment. Alright, the defendant here didn't beat the claimant or didn't assault the claimant. It was simply an unlawful harassment. Sexual harassment is another area. Most of us are familiar with it. Someone follows another person, sends unwanted messages, phone calls, pictures, then it's sexual harassment, which falls under the category of unlawful harassment. The person can be sued with tort law and even possibly with criminal law. Invasion of privacy is another underdeveloped area of tort law. One's right to personal life and family falls under the category of invasion of privacy. Any deliberate invasion of privacy, like photographing the personal lives of the claimant without the latter's consent, it falls under invasion of privacy. Next, we come to negligence. This is an entirely separate, the second area of tort law. Let me show you. Yes, we are talking about this. We have already completed intentional tort. Now we are coming to negligence. Let's see what it's all about. You can understand from the name, negligence means the wrongdoer, the defendant, has been careless in such a way that the legal interests of the victim or the claimant has been harmed. I've been so callous, so careless and inattentive that it has harmed somebody else. That's negligence. There's an example here. When the defendant carries out the act of constructing something in her garden, she owes a duty of care towards the claimant. The standard of duty care depends upon whether the claimant was a trespasser or a lawful visitor. What this example is saying that if I live in a public place, definitely my house is my personal space, but the garden is somewhere, maybe people will come. If I can reasonably foresee that somebody may come in and get harmed, then I cannot build something in my garden which can harm others, which can injure others, or which can otherwise be harmful to another person. I have to take this care as the owner of a property. And it depends upon whether the person was a trespasser who came in without my permission or it was a lawful visitor. There are 3 elements that must be established by the claimant to prove that the defendant has been negligent. First of all, defendant owes a duty of care towards the victim. A duty of care means that I have to be careful for somebody. I have to take care of somebody. The second thing, there has been a breach of duty of care. My efforts to fulfill the duty of care has not been fulfilled to a great extent. There has been a failure in my part to do it. That's the breach of duty of care. Third thing, the breach of duty of care has resulted in a harm suffered by the claimant. Since I have not been able to do the duty of care, since I have failed to perform my duty, it has resulted in a harm to another person. These 3 elements, if present, then we can constitute a perfect case of negligence. Now let's look into this area of duty of care. First and foremost, we learn about a very important, this is a must learn thing, Donog versus Stevenson case, a very interesting case too. What happened? The claimant Donog, her name was Mrs. May Donog. She drank a soft drink manufactured by Stevenson. He was a businessman, perhaps, a manufacturer of the ginger beer. And the drink that she had a decomposed snail in it. Now, Mrs. Stevenson drank some portion of the drink and she discovered that there was some dirty bits. It was a snail which was decomposed. Now, immediately after seeing this, Mrs. Donog had a kind of a nervous breakdown. She suffered from a shock because she had consumed such a dirty thing. Now she sued the manufacturer. His details she obtained from the label of the ginger beer can. The court in this case held that the manufacturer owed a duty of care to all those who were reasonably foresee. See, if I am the manufacturer of a product, I should owe a duty of care to the consumers of my product, the ones who will be drinking my soft drink or will be eating my fast food or whatever it is, or anything. Like if I am a cosmetics dealer, I have to take care that my product shouldn't cause any harm to the skin of my consumers. These things are important. I have this duty of care. If I cannot do that, then I am doing a breach to the duty of care. In this case, the court held that Mr. Stevenson, the manufacturer, was unsuccessful in fulfilling the duty of care. Again, we have an example here. The landlord owes a duty of care to the tenants with reasonable foresight. For instance, if I am a landlord of a house and I have given my house on rent to someone, I cannot store hazardous thing in my house which can catch fire easily. For instance, if I store gallons of petrol in my basement and I have given the apartment on rent to someone, because of some incidents, my petrol may catch fire. This can be detrimental for the health of for the lives of the tenants in my house. I cannot do this. That's my duty of care. If I don't do this, if I fail to do it, and if the house catches fire, there is a breach of duty of care. And this breach has in fact resulted in a harm to the claimant. So these three elements are being fulfilled. So we have already done, I have also explained this entire thing in one example to you, but still in your textbook, breach of duty of care, harm to the claimant, these three things have been separately mentioned. So you should read it. See, the defendant was unsuccessful in fulfilling the duty of care in accordance with the standard of reasonableness. Reasonableness is two things: reasonable conduct and reasonable foresight. I can reasonably foresee that my consumers will be impacted by the quality of the product that I am manufacturing. That's the reasonable foresight. In reasonable conduct, I have to be careful in whatever I manufacture. In Donog versus Stevenson case, the manufacturer was unsuccessful in doing so. Last but not the least, harm to the claimant, as I have already mentioned, some sort of injury in the legally secure interests of the claimant or otherwise. That's harm to the claimant. Apartment in my example catches fire because of petrol being stored in the basement by me. In this case, I am the defendant since I have done this. That's it about negligence. Now I come to strict liability. You see, this chapter is actually short but very important and interesting too. Strict liability. The tort of strict liability doesn't care about intention or carelessness of the defendant when he caused the harm. You see, in negligence, in intentional tort, it's essential for the claimant to establish that I have been negligent, or I'm saying the defendant has been negligent in some way or the other, that the injury has been caused on purpose by the defendant. In the case of strict liability, there is no need at all for the claimant, for the victim, to establish any sort or level of carelessness in my part. The claimant doesn't have to establish any form or level of blame attributable to the defendant based on intention or the level of carelessness. Two examples: when the defendant's animal causes an injury to others, or when the defendant is involved in an unusually hazardous activity. This is called ultra hazardous activity which is very important for your exam. Why? Because the concept of absolute liability was created in India. That's why in your board exams it's their favorite question to ask questions from it, since it was developed in India. Otherwise, we are learning about many things in tort law which were created in England, like the Donog versus Stevenson. It was an English case. Now, strict liability, the tort of strict liability doesn't care about the intention, as I said. Now, when the defendant is involved in an unusually hazardous activity, blasting dynamite or something else, involved in a factory involving works with gas or nuclear energy, in these cases, one sort of, you know, carelessness, one instant of doing something which will result in a leak can result in harm and death to thousands of people. In this case, I am strictly liable for any harm that is being caused to people around me. Now, if the defendant has an animal with a known and unusual dangerous tendency, the defendant is strictly liable for the harm caused by the dangerous tendency of the animal. That's the thing. For instance, if I have a dog that bites, then I have to be responsible that my dog doesn't bite anybody who is unknown to me. But in a different case, if I possess a bull, obviously bulls will be aggressive. It's a normal tendency. It's not a, unusual dangerous tendency. A bull will be aggressive. That's a normal tendency. I won't be sued if my bull harms somebody else. The person, it's a responsibility of that person to be careful around a bull. Now we come to ultra hazardous activity. When the defendant carries out or keeps an unusually hazardous situation in his or her building, or is involved in an activity that offers an inevitable danger of injury to the claimant, the defendant could be responsible for the damage even if he or she has taken reasonable care. Now, if I am the owner of a factory dealing with gas work involving, suppose, methyl gas or some other things that can be hazardous for the health of people, if leaked, then if there is any injury, if there is any accident, then I cannot defend myself by saying that I have taken reasonable care to prevent the harm. If there is anything that is happening, then I am absolutely liable to pay compensation for it, absolutely liable to be able to accept my guilt for it. That's the rule here in ultra hazardous activity. Absolute liability is a relative principle in India, as I said, developed by Supreme Court in the aftermath of two infamous gas leaks. Now, this is extremely important. Two gas leaks, Bhopal gas leak disaster of 1984 and Sriram Foods and Fertilizers Industry 1985. A factory of the Union, now I'm doing the first gas case, alright, this was the more severe case. A factory of the Union Carbide Corporation, very important names, and the name of the gas is also important. It was in Union Carbide Corporation located in Bhopal. It had a major leakage of gas methyl isocyanate, killing 2,260 people, injuring 600,000 people. You can understand, so many people died and so many people were injured, causing harm to so many people. Even the women who were pregnant, their children were impacted. We have seen in this Bhopal gas leak disaster. So, Union Carbide Corporation is the name of the factory, methyl isocyanate is the name of the gas. Next case, Sriram Foods and Fertilizer Industries. This case was fought in 1985. And this was a factory in Delhi which leaked oleum gas. In general, what we do, we interchange, by mistake, we confused between the two gases. The first one, in the case of Bhopal gas leak disaster, is methyl isocyanate. In case of the food and fertilizer industries, it was the oleum gas, and this was a milder one. It killed one person, a few others were hospitalized and injured, and it created panic among residents because just 1 year before there was this gas leak, this disastrous gas leak in Bhopal. That's why people were very anxious about this one. Now, there was, in the aftermath of this disaster, in the Sriram Foods and Fertilizer Industry case, there was a very famous case fought in Supreme Court. The case was MC Mehta versus Sriram Foods and Fertilizer Industries case, fought in 1987. It declared that any enterprise engaged in an inherently dangerous and hazardous activity owes an absolute and non-deligible duty of care. The dangerous activity conducted should be done with the high standards of safety, and in case any harm is inflicted, the enterprise should be absolutely liable to compensate without any debate. I will be explaining this once again. Now see, who was saying all this? Who established all this? It was the then Chief Justice of India, P.N. Bhagavati. In this case, in MC Mehta case, he declared that anyone who is involved in an inherently dangerous thing, inevitably and inherently dangerous activity, like say working with dynamite, or in such a factory working in gas and chemicals, such persons, such owners, they owe an absolute and non-deligible, which means unarguable, duty of care to the workers and residents surrounding the area. This dangerous activity should be done with the highest standards of safety possible. It has to be done keeping in mind the highest amount of care that we should take. Security, all the kind of precautions has to be taken. And in case there has been some harm inflicted to people of the neighboring areas, the enterprise should be absolutely liable to compensate without any benefit. We cannot say that I have taken reasonable care, I have done everything, I have taken all precautions. I simply cannot say that. I have to give compensation to whoever has been impacted. That's the MC Mehta case judgment, a historical judgment. This was by P.N. Bhagavati. Alright, with this we come to an end. You see how small this chapter is. In fact, last but not the least, this is not that important, but still, since you have to write an exam, we will be doing this too. Summary of the kinds of harm, because every part of your textbook is important, from words to boxes to everything. I will be doing the boxes once I complete the syllabus. Alright, and if you are finding this video good, then please like the video and subscribe to my channel if you have already not done. Please share it with your friends to spread the video, to help your friends and to help me to grow the channel. And you can write a good comment to cheer me up also. Alright, now summary of the kinds of harms. Now, what does tort law include within its purview? Economic interests, property interests in land, then bodily injury and other types of property. These are the four broad categories. Economic interest means, to a lesser extent, economic interests are protected. Harm can be caused by intentional or negligence issues. Tort protects everything about our economic interests. Property interests in land, obviously we know that trespass to land, trespass to chattels, conversion, these protect our interests in land and property. When the defendant interfered with the claimant's rights to enjoy the property, the tort of nuisance is applicable. Nuisance means I have been preventing someone else from peacefully enjoying a property. That's nuisance. Tort of nuisance. So this is the property interest in land. Other types of property, it prohibits taking away tangible property deliberately. It amounts to conversion. Damage can be because of negligence and careless, obviously. Now, this is just a simple conclusion we can say. Bodily injury, tort law protects the claimant's rights. The claimant's rights to his or her bodily integrity. Tort of battery and assault protects the intentional harm. We have tort of negligence, which prevents any manufacturer from manufacturing faulty products, defective products or services, and the breach of statutory duty in the form of traffic laws and health laws. That's it about tort law. There is nothing else. If you want, I can also make a question answer video once I complete the syllabus, but till then, bye.